On behalf of the Sikkim Judicial Academy, I would like to warmly welcome each one of you to today's program on training on sale, gift and lease under the Transfer of Property Act 1882. I would like to inform the House that this training program was designed to revisit the fundamental principles and also to address the practical issues arising in adjudication, particularly in our local context. It is earnestly hoped that today's deliberation will serve as a meaningful exercise in enhancing both conceptual clarity and judicial approach. We are deeply honored to have with us today Mr. Anmole Prasad, Learned Senior Advocate, High Court of Sikkim, as the resource person. It is my privilege and honor to introduce our esteemed resource person. Learned Sir was born on 3rd April 1955 and completed his schooling from Kalimpong. He graduated in economics from Kirorimal College, University of Delhi, thereafter obtained LLB degree from Campus Law Center, University of Delhi in the year 1978. He has been in active legal practice since 1981 and has appeared before various courts across the regions, including Darjeeling, Siliguri, Sikkim and other jurisdictions, as well as before the Honorable High Court of Sikkim and High Court of Calcutta. In recognition of his standing at the bar, he was designated as a senior advocate by the High Court of Sikkim in the year 2008. He is also a lifetime member of the Sikkim Bar Association. With his vast experience in advocacy and a deep understanding of property laws, we are indeed fortunate to benefit from his expertise. We express our sincere gratitude to you, sir, for graciously consenting to be the resource program for this program. Felicitation as a mark of deep respect and appreciation, may I now humbly invite Learned Deputy Director, Madam, to kindly felicitate Mr. Anmole Prasad, Learned Senior Advocate, High Court of Sikkim. Thank you, Madam. Before we proceed further, I would like to inform the House about the structure of today's program. The training session will be conducted in two parts. Each session will be approximately of 1.5 hours. After the first session, we will take a short break of 15 minutes. Thereafter, we'll continue with the second session, followed by lunch. With these words, I respectfully invite a learned resource person to kindly take the session forward.
Members of the Judiciary, ladies and gentlemen, a very good morning to you. I'm sorry, I'm suffering from a sore throat, so my voice is several octaves lower than...
Voice sounds very good, sir.
Thank you. It's First of all, I would like to extend my heartfelt thanks to the Sikkim Judicial Academy for having me. It's a pleasure as well as an honor to be amongst so many judicial officers with whom I have again had the pleasure and honor of appearing and of sharing long friendships with, in fact. And unfortunately, this subject is as dry as my throat. Transfer of Property Act, I haven't visited it for a very long time. And while thinking about the Transfer of Property Act, my thoughts went to its origins, to the headwaters of the Act, 1882. Why are we still with a law that was framed in 1882? And that takes us further to, takes all our thoughts further to the fact that so many of our laws come from that period, the late 19th century, when the Evidence Act, the original Criminal Procedure Code, and so forth. They were the Easements Act, the Indian Trust Act, Powers of Attorney Act. These were enacted in the latter part of the 19th century. and we are still using them to this day. The language is archaic from another time and age, and was used for enacting laws that were needed in that time and age. So I thought it would be interesting to take a look at that before we come to the law of the present day. Now, as we see, and I chose this image from the Government of India Act, and the first line. We have this act passed in 1858, and when we think about that time, we also think about the great events of 1857, when the first uprisings against the British began, and what must have been in the minds of the rulers of Imperial India when they passed this act. If we cast our minds back to those days, this was a moment when the English state decided that no, it's not the East India Company that should be in charge of the affairs of India, and that it should be ruled directly under the crown. So we see this image, and it tells us Victoria Regina, the rule of Queen Victoria. And the first line of the Government of India Act says, an act for better government of India. Now, it's not that this is the first time the British are thinking about this. The British are already thinking, because the first Law Commission has already submitted its report, and by the time the Indian Transfer of Property Act, comes into being just before that, it's the third Law Commission that is there. And Lord Macaulay in 1835 has already delivered his infamous minute, which was the subject of great controversy in the Parliament also, about how they were going to reshape India's education so that they would produce company men, people who were better able to serve the empire and act as an intermediary between the Raj and India itself. So this is in 1835, it's already over. The third Law Commission is already then on enacting all these laws, because prior to the enactment of the Transfer of Property Act, the courts have been pretty much following English law according to the principles of natural justice, equity, good conscience, in dealing with transactions of properties in India. But I felt, I would just conjecture, because I'm no historian, I would conjecture that the Crown must have then realized that we need some kind of legislation by which we can formalize. It wasn't a code, but they could at least formalize transactions in India pertaining to property. With these issues in mind, the Transfer of Property Act was enacted. Also, it is probably pertinent for us to remember that this was Imperial India, and as some historians might say, it was actually the global moment. Globalization was already there, because trade and commerce was, due to the expansion of the British Empire, trade and commerce was flowing across the world. Wars were being fought, goods were being fought over, especially with China, and that had a huge impact on India. So, why I draw your attention to that moment is because we are indeed today also in such a moment. And therefore this ancient law, which didn't undergo very many radical amendments, except perhaps in 1929. This law now takes on a new shape in this day and age when liberalization is upon us, our markets are open, and we have to deal and contend with trade and commerce and the transfer of property within and without the nation. So, in that sense, the full circle seems to have come as we fight over oil in the Middle East, and nations are being decimated and recreated and dismembered, all for the sake of money and capital. So, it bears, I think I'm a little, this text is, never mind, since it seems to be weird. Yes.
It's clear, sir.
It's clear. So the Act says, I won't read the entire portion, but if we look at section 1, 2, the first line is quite revealing. India shall be governed by and in the name of Her Majesty, and all rights in relation to any territories which might have been exercised by the said company, that's the East India Company, if this Act had not been passed, shall and may be exercised by and in the name of Her Majesty as rights incidental to the government of India. These are my prefatory words before coming to the subject that we have today. The Transfer of Property Act is laid out in 8 chapters. If you bear with me, I'm a little unfamiliar with this software. Concerned with the sale of immovable property, leases and gifts, and the remaining chapters are on mortgages and exchanges. In many ways there are some aspects to this which are interrelated. But if we look at the salient features of the Transfer of Property Act, Section 5, to my mind, I'm just going to touch upon some of the important sections that are there. Transfer of property. Defined. The following sections of transfer of property means an act by which a living person conveys property in present or in future to one or more other living persons or to himself and one or more other living persons, and to transfer property is to perform such an act. Now, the elements of the Transfer of Property Act, which defines the transfer itself, has certain salient features. It allows the transfer in present or in future, and it's inter vivos, so it has to be between living persons, and it can also be transferred to the transferor himself along with some other person. Section 6 tells us what may be transferred and defined as property of any kind, and it lists 10 exceptions. Now these 10 exceptions obviously you all are familiar with and need to maybe read up if necessary. But in these exceptions there is one exception which is quite interesting, which is what is known as successionist, a chance of succession. That cannot be transferred. The other interesting thing that cannot be transferred, if we look, is a mere right to sue at clause E. And clause C, which also I found interesting, was an easement cannot be transferred apart from the dominant heritage. This is especially interesting because in the law of easement we have the subservient heritage and we have the dominant heritage, and an easement is exercised upon the subservient heritage by the dominant heritage. So if I have a piece of land and I have an intervening land of my neighbor between my land and the highway, and I've been walking continuously there for a period of over 20 years, I acquire an easement over his subservient heritage. But this was thought through in the Transfer of Property Act quite thoroughly, that if I sell my land, which is the dominant heritage, then I can sell the easement to my new buyer by saying that here's my land, and then he asks me, but your place is not connected to the highway. Then I can tell him that I have a right of easement over the subservient heritage which is intervening between my land and the highway. But a reservation, an exception was made in the Transfer of Property Act that you can't sell the easement alone. So you can sell your land along with the easement, but you can't sell the easement alone. So you can't find a buyer and say, listen, I have a right of way here, or I have a right to draw water from that land, or I have a right of air, light and air, which I want to sell to you. It's hard to imagine a situation where anyone would try to sell an easement, but at the same time it does make sense, because if there is a man with a property attaching your easement, say a right of way, and you have exclusive right of way there, you can't tell that man that, listen, I'll also allow you to use the road as per my easement, provided you pay me X amount of money. That is an exception provided by the Transfer of Property Act. It's impossible for us this morning to get into the minutiae and the granular reading of this act. So I'm just touching upon some aspects which to my mind, I found interesting. And of course, excuse me, a right to sue cannot be transferred. So that, as we all know, is anathema to the law, that I should be able to sell an action which is relevant to me to someone else. Then, Section 7, competence to transfer. This is an interesting provision. Every person competent to contract and entitled to transferable property or authorized to dispose of transferable property not his own is competent to transfer such property either wholly, in part, and either absolutely or conditionally in circumstances to the extent and in the manner allowed and prescribed by any law for the time being in force. A very general provision. But competency, as we know, also depends upon minority for one thing, or for mental soundness of mind for another. There are situations where people are not competent to transfer. Now, here the law provides that the transferee, the person who buys, can be a minor. So a minor can acquire rights in a property, but a transferor has to be competent, so a minor cannot transfer. There are exceptions, obviously, in the case of guardians for the benefit of minors, as we know, but a minor per se in his own right cannot go to a registry and say, I'm signing away my land and I'm selling my land. So, as far as competence is concerned, Section 7 provides for that. Then, some interesting aspects of Section 8. Unless a different intention is expressed or necessarily implied, a transfer of property passes forthwith to the transferee all the interest of which the transfer is then capable of passing in the property and in the legal incidents thereof. Pausing here for a moment, since I work in two jurisdictions, in West Bengal mostly and in Sikkim, I've had the opportunity of looking at conveyancing in Sikkim and in West Bengal. And when we draft deeds in West Bengal, we are entitled to draft it in any manner that we choose to do so, because it depends from client to client, from transferor to transferor. We can draft out our deeds. But in Sikkim, for example, this sales, for example, are carried out by filling a form. Now, I would come to that later, but we can think about this now. In the context of operation of transfer, when we say, when in the Hebendem clause we write, to have and to hold the scheduled property, together with all easements, appurtenances, chattels attached to the ground, or relevant or necessary for the enjoyment of the said property, as a matter of abundant caution, so that when a property is transferred, everything, all the incidents of that property are transferred. It's not necessary to write, because as you see, the law provides for it. But this is the tradition, and in drafting conveyancing there, lawyers tend to write much more than is needed, so that absolute ownership rights are transferred. The reason for that, and in my experience as a lawyer of 41, 42 years, the reason for that is that sometimes, somewhere down the road, that raises its head. The problem raises its head. A simple thing like a farmer, and he has a kulo that used to come from the stream, and somebody interferes with that kulo, or the transferor himself interferes, says, that's when these deeds, the recitations and the clauses that are in the deeds become very, very relevant, and then they in fact become game changers, because then they enable the transferee to exert his rights, because all those are incidental to the rights, ownership rights over the property. It's not enough for us to do that. I miss that in the conveyancing in Sikkim, where there is hardly any space in those forms for making those things. Sometimes there are, very special circumstances in which removal property is transferred, and it could be something like the user of a bridge across a stream, which is vital for the enjoyment of that property. But we don't see that, and I feel since I think people who are capable of making change are all present here, I feel that this is something that the legislature and the bureaucracy, as well as the judiciary, could look at to create a new form of conveyancing in Sikkim which would cover these aspects. Of course, I am aware of the fact that because we are trained in the colonial tradition, we always tend to overwrite. These deeds become verbose and lengthy and almost unreadable compared to the Sikkimese simple form. But there's a middle path where we could probably find, and that is being done, I think, especially in the realm of corporate law, and where new ways of conveyancing and drafting have come in. In the case of what is transferred, there is also something interesting here, and that is some incidents include where the property is land, the easements annexed thereto, and the rents and profits thereof accruing after the transfer, and all things attached to the earth. There was a case in the Madras High Court which was directly upon this point. And there is something that also creates a little dissonance for me. If we go back to section 3, I haven't quite thought this through, but in the interpretation clause, immovable property does not stand timber, growing crops or grass. For some reason this has been put in, whereas if we go back to section 6, we see, section 8, we see such incidents include where the property is land, the easements attached, the rents, profits, etc., where the property is machinery attached to the earth, the movable parts, where the property is a house, easements annexed thereto, rents thereof for providing permanent use there, etc. So it stands to reason that trees, standing crops would be automatically transferred. Of course, the transferor can reserve the right to say that, no, I will harvest the crops, which is not that. But interesting aside was in a Madras High Court judgment in Board of Revenue, Chepauk, Madras, in 1955, Madras 620, where there was a cinema which was attached to the earth. The projectors were embedded in the ground, the tents were there, and it was claimed by the transferee that once I bought the land, all this became mine, and that led to a dispute before the courts. Fortunately for the cinema company, the name of the company it had the word touring cinema in it. And the Madras High Court, on the basis of that, said no. It said, although some of the machinery or poles of the tent may be embedded in the earth, they were embedded only temporarily, as the equipment of a touring cinema and therefore equipment is of a touring cinema and therefore not falling within the category of immovable property. So there are these nuances in the law where the definition of immovable property can be this way or that way, depending on the facts and circumstances of the case. With these, we will come directly to sale. Sale includes two fundamental components as set out, and they are that there is a transfer of ownership and it has to be in exchange for consideration. In the case of tangible, it says sale is a transfer of ownership in exchange for a price paid or promised, or part paid, or part promised. Sale how made, such transfer in the case of tangible immovable property of the value of 100 rupees and upwards, or in the case of a reversion or other intangible thing can be only made by a registered instrument. And this has been the stumbling block of many a transaction. In the case of tangible immovable property, delivery of tangible immovable property takes place when the seller places the buyer or such person as he directs in possession of the property. Now, these elements of a sale are very interesting. For example, if we take the idea of consideration of price, It is the payment of money. And in the case of, say, for example, exchange, which is a separate chapter in the Transfer of Property Act, there's no passage of money. Property is bartered for property. So that's a different kind of a transaction for which the statute provides a very separate. Good morning to you, sir. A separate definition and a separate transaction set aside as exchange. But in the case of a sale, we need a consideration price to be paid for the passage of the interest. The High Court has reviewed the legality of the trial court's finding in a dispute relating to ownership and possession. And I'm sorry to struggle with this. I'm trying to find my file, but I think that judgment is with you and we will not delay things more. It held that evidence on record didn't warrant interference and consequently dismissed the appeal. But there at para 35 of a judgment of this High Court in Uendra Thapa versus Chauhan Doji, RFA number 2 of 2022, His Lordship held, after citing section 54, sale defined, sale is a transfer of ownership in exchange for a price paid or promised or part paid, etc. The court held that a contract for the sale of immovable property is a contract that a sale of such property shall take place on terms settled between the parties. It does not of itself create any interest or charge on such property. In Suraj Lamp, the Supreme Court held that a transfer of immovable property by way of sale can only be by a deed of conveyance, sale deed, in the absence of a deed of conveyance duly stamped and registered as required by law. No right, title or interest in an immovable property can be transferred. As experienced judges, of course, you all know this, but I thought it is such an important aspect of the transaction of sale. And at para 40, the Lordship said that thus the declaration of ownership by the learned district judge based on an assertion of an oral transaction and possession is incorrect. So therefore you cannot have an oral transaction of a sale. It has to be in writing and by a registered instrument upon which the stamp duty is paid. Then further, in this context, the trial court ought to have borne in mind that the Supreme Court in a plethora of judgments has held that documents of title do not give ownership unless the transactional documents, that is the documents of conveyance, is shown how the land was transferred from the previous owner to the owner who claims title and possession. In Ramesh Chandra Ted, through LR Legal S versus Suresh Chand and another, it has been clearly observed that in a sale of immovable property, the value of which exceeded rupees 100, the three requirements of the law that are the transfer of property of sale must take place through a validly executed sale deed. It must be in writing, it must be properly attested and registered. Unless the sale deed is in writing, attested and registered, the transaction cannot be construed as sale, or in other words, the property will not be transferred. Thereafter, the Lordships referred to the Suraj Lamp case, and the Suraj Lamp case is somewhat of a cause célèbre in India. It is a judgment that sent reverberations through so many transactions across most of the metropolitan cities of India, where entire apartments and entire properties were being sold on the basis of general powers of attorney. And especially in Bombay, and I have had personal occasion to see how these transactions have worked, where apartments change hands one after another because of skyrocketing real estate prices. People are buying and selling, and the moment the price goes up, people sell. And the entire operations is in the hands of the local agents and the local mafia. To the point where it was astonishing to see that people's ownership papers were all general powers of attorney, given by a person whom they didn't even meet. It could have exchanged hands several times. And people were, almost a parallel economy was formed around this, where you would sell it and the buyer would see, do you have a power of attorney? Yes, here's my power of attorney. Pays the money and buys the thing. Sorry. This reached such scandalous proportions in the Suraj Lamp case that the Supreme Court was forced to take notice of it. And the Supreme Court, I think probably all of us have seen this, the Suraj Lamp being referred in one judgment or the other of the High Court. It's such a well-known judgment that the Supreme Court said, how can you do this, in the teeth of the provisions of the law, which requires a registered instrument duly stamped and attested? How can you have real estate? The Supreme Court outlawed this completely in the Suraj Lamp's judgment and said, no, nothing doing. All these transactions are invalid. And then it put an end. The other more important outcome of these transactions was a huge black economy, because then I'm paying cash, I'm getting a general power of attorney. I have black money. I cannot register the document because then the money will show up in my tax papers, and therefore much easier for me to do a sale agreement and a general power of attorney. But after Suraj Lamps, I think there has been a huge reduction of this kind of practice. And this High Court of Sikkim also referred to that in this Uendera's judgment, where it said, the Supreme Court in Suraj Lamp Industries, through etc., was considering whether the transfer of immovable property can be executed by a general power of attorney sales or sales agreement. While holding in the negative, it was elucidated that immovable property can be legally and lawfully transferred and conveyed only by a registered deed of conveyance. Provision of law, we can all read it. I mean, there are a number of rights and liabilities, but the operative part about this is that the law itself sets out the rights and liabilities of the buyer and seller with the caveat, in the absence of a contract to the contrary. So if there is a contract in the conveyance that there are other terms and conditions, these may or may not apply. But these are very salutary provisions which the law provided for. And this is something that also raises its head in transactions. For example, I'll just touch upon a few examples. The seller is bound to disclose to the buyer any material defect in the property or in the seller's title thereto, of which the seller is and the buyer is not aware, and which the buyer could not with ordinary care discover. Buyers often go and do a search for loans or for other encumbrances, but the lawyer who goes and does that search is also limited, because he can only ask the bank or the Chrysler ratings what kind of credit has this seller got? Has he taken a loan on this land? And he can go to the courts and ask for information, is there any litigation pending regarding this property? And then he tells the transferee, the property is free from all encumbrances. The law provides that the seller has a duty to let him know. For example, he may have a brother who is not disclosed and the brother's name is not on the Parcha Khatyan. So the buyer looks at the Khatyan and says, oh, there's a single name, that's fine. The duty of the seller is to make these disclosures. And now, for example, the seller also has duties which are set forth in this section. And we really don't have the time to go into the minutiae of this, but now, as we know, especially in large contracts, large transactions between corporates, there is a word which keeps coming up which is called due diligence. And due diligence actually is a phrase that covers all these due diligences that are embodied in section 55. I found one section which was rather interesting. The buyer is bound to disclose to the seller any information that materially increases in the value of the interest he is purchasing, which is not in the knowledge of the seller. Now, this is a rather complicated thing. Sorry, I'll just go on. It's the buyer who has to disclose to the seller any information that increases the value of the interest he has. Now, why should the buyer tell that to the seller? Why should the buyer tell the seller that your property is worth more than what I'm paying you for? It's a kind of a reverse situation, and it sounded rather strange to me. So I went and looked at some of the examples in the law, the judgments that have been decided. And there were two instances which were very remarkably contrasting. In one instance, the court said, for example, if the buyer knows that there is gold in the land that he is buying, is he under an obligation to disclose to the seller that, listen, that land I am buying from you has got gold in it? The court said no, he is not bound to disclose that. Then I began to wonder, then what is he bound to disclose? Came across another case where there was an elderly widow and she was selling a part interest in the property. The buyer was buying a part interest. But the buyer knew that the old lady was actually the full owner of the property and she didn't hold a part interest in the property. In that case, the courts held that the buyer must tell the old lady, because she doesn't have this information, that she is the full owner of the property. So there, his obligation under section 55 will come, and he has to inform the buyer that, listen, the property that I'm buying from you, I'm not buying your half share. I'm buying your full share. And therefore, this property is worth twice what I'm paying you. And there, if he does not so disclose, then the transaction stands void. All these little nooks and crannies of the Transfer of Property Act, I mean, we could go on the whole day on this. But I've just selected some of the portions which caught my eye. Then I'll, before departing with the from this chapter. There are certain distinctions, as I said before, we have to make. And these distinctions, I mean, they are taught in law school and very commonplace, but still, nevertheless, I'll make my point. A sale is distinct from a gift or an exchange. The reason why is that consideration does not pass in a gift or in exchange. A sale is distinct competence. A purchaser need not be competent to contract and therefore can be a transferee, but a minor cannot be a transferor. Transfer of the interest in intangible movable property transfers on the date of execution and not on the date of registration unless a contrary intention is shown. This is very important because the registration could take 4 months to complete. That happens in Sikkim quite often, where we see that the sale deed has been executed on one day and the registration is dated sometime in the future. The question then arises as to when the interest transferred. And it's generally taken that it transfers on the date of the execution. And an agreement to sale, which is very commonplace everywhere in this country, just an agreement to sale does not transfer any interest whatsoever. An agreement is an agreement. Perhaps the payment of advance can be shown by that, and even so if it is registered. And this becomes exceptionally sharp, this point of registration, in a case of part performance, which I'll talk about now. 53A is a very interesting provision. Part performance, where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has in part performance of the contract taken possession of the property or any part thereof, or the transferee being already in possession continues in possession in part performance of the contract and has done some act in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract. This is the operative part of this law. Then, notwithstanding that, or where there is an instrument of transfer, that the transfer has not been completed in the manner prescribed therefore by law for the time being in force, the transferor or any person claiming under him shall be debarred from enforcing against the transferee and persons claiming under him any right in respect of the property of which the transferee has taken or continued in possession, other than a right expressly provided by the terms of the contract. This is a very, very convoluted piece of legislation, and it takes anybody a bit of time to unwind it. To simplify it, and I've had occasion of dealing with this 53A in many cases, where what happens is that a sale agreement is made. The buyer pays an advance. The seller then finds out, oh no, I'm getting a better price somewhere else. The buyer else takes possession or he's already in possession. This already in possession happens usually in the case of a tenant who is buying from his landlord. He is already in possession and he says, "Mero maha yati paisa cha hazur, malai bechidinuhoस्." The landlord also says, and a sale agreement is made. The buyer is in possession of the property. The seller has title to the property. This is a situation where possession and title become bifurcated, and there is an agreement to sell. The Section 53A was developed by the courts of equity in England, because they also came across this very intractable situation. There's a sale agreement, the buyer's in possession, and he has paid the advance, and he's saying, I'm willing to pay the rest of the money. He has to express that. I'm willing to pay you the rest of the money. Just execute the sale deed in my favor. And the seller says, no, I'm not going to do that. Now, of course, he can be sued for specific performance, etc. We know all that. But in a situation like that, the Transfer of Property Act protects the buyer and says that it's very convoluted. The transferor, I'll just highlight that so that we can be on the same page. The transferor or any person claiming under him shall be debarred from enforcing against the transferee. Then we go, any right in respect of the property of which the transferee has taken or continued in possession. Therefore, he cannot dispossess the buyer from the property. Now, this is very equitable in the sense that the man is saying, I'll pay the rest of the money, you better perform your part of the contract. That's what we would all say. But I've seen situations, and I can also conjecture that there will be situations, where the seller says, no, I won't sell, and the buyer is in possession. And it goes on for a long time. The seller cannot get the property back, and the buyer cannot get the title from the seller. This is a problem that this particular provision of law has not addressed in its entirety. It leaves open a dispute maybe for generations to come. The buyer dies, his children are there. The seller dies, his children have the title papers. It creates a deadlock. And this deadlock, I don't think the law has been able to break.
So actually that's why he specifically said that we should actually take recourse to specific.
Specific relief, yes. Yes, Yam.
But in maximum cases, in some of our property, in Sikkim and outside also, I've seen that we are in possession. Agreements have been drawn, payments have been done. Possession we have built the houses, bungalows and all.
Yes.
And but the mutation is still not there.
It's still not there. Exactly.
So I was wondering, at that point of time, your good friend, should have filed a case on that.
Yes.
I was wondering.
Yes.
But they won't do it because after all they are still in good relations, the buyer and the seller.
Yes. He's hoping that maybe.
Exactly. So now, the time for them to leave, and some of us are in a quantities.
Yes.
So it's absolutely right.
And the difficulty is, as in Bengal we have the Limitation Act, the limitation for performance is 3 years only. You know, if that gate is passed.
So what would be the solution? I don't think anyone else apart from serve the what would be the buyer or people under it? Can it go on and on and on?
It's, you have touched upon the problem right in the nerve center, that this leaves open the scope for disputes for generations to come. I would think that the law should make an exception of limitation in this case, because possession has passed, and therefore it's a continuing transaction. So a man who has paid an advance and has been given possession of the property, and mind you, possession of the property is never lightly given. It's given after a bulk of the consideration has passed. And if he is able to genuinely say that here is the money, I'm willing to pay the rest of the consideration, then the law of limitation as far as performance is concerned, specific performance is concerned, that exemption should have been made in a case like this. Where I might have bought it maybe 2 decades ago, but I'm saying here are my notices, I'm sending letters saying please finish the transaction. You know, I don't want this hanging on my head. If I will be able to show this and I'm able to show my finances, then they should be allowed to seek performance outside.
There's another thing. If you say small plot of land, let's say 100 so one can understand this possession, taking possession is legal. But what if there are swords and swords of land, acres and acres?
Yes, I'm coming to that because there's a proviso which is even more problematic than this.
And between the owners,
Absolutely.
Exactly maximum from your.
If I may inform the House, sir has been chewing my brains for a pretty long time in court.
Not only your brain, sir.
Everybody's, absolutely. So this was a doctrine of equity, and in the Chancery Courts in England. And in 1929 it was incorporated. This is a very old law that we see. At first blush I thought this was a post-independence provision that had been enacted, but it goes back to 1929, where it was given a statutory expression. And there also some of the courts had enforced it, even to the pre-amendment transactions, but eventually the Privy Council said nothing doing and refused to enforce it at that point of time. Now, the aspect about this is it creates a limited right against the transferor. And in India also the courts have said, I cannot go to a court of law and say, give me an injunction, the seller is trying to dispossess me. So the principle that has been followed by the courts consistently is that it is a shield, but it's not a sword. You can't go to a court and enforce that right of given to you under 53A to the buyer against the seller. But if the seller comes and says, I want recovery of possession in a suit, then you can say that no, 53A allows me to remain in possession, although I don't have title. Now, the even bigger problem in this section, I hope I'm not getting too deep into this, but this is something that has also mystified me. Provided that nothing in this section shall affect the rights of a transferor for consideration who has no notice of the contract or the part performance thereof. So now if a third buyer comes and he says, I'll buy the property from that bad man, the seller. And the seller says, all right, he gets a higher price, he sells it to the second buyer. Then that defense is not available against that second buyer if some conditions are met, that the second buyer did not know about this part performance and he had no notice of this contract. That opens up a huge Pandora's box, because the seller can enter into a collusive transaction in order to get his property back with X, Y, and Z. Let's say, just to simplify it, A sells the property to B, B pays the advance and has an agreement. Then A refuses to complete the transaction with a title deed. And then A contracts with C and says, here, you take the thing. B can defend himself against dispossession from A, but B cannot defend himself against dispossession against C. If C says, oh, I didn't know about this transaction. This is another complication which the law has provided. It's an anomaly, and I don't think it safeguards against collusive transactions where A tells C, listen, this man is there in possession, but you pretend that you don't know about this, you have no notice of this, and you're coming from Calcutta, you just say you bought it. And I didn't know about this because I'm in Calcutta, this property is in Gangtok. So therefore, as Sirs rightly pointed out, possession, if in the case of a tenant, obviously you can say that, come on, see, why didn't you go and see the property? There was somebody living there. But in the case of vacant land, large pieces of vacant land which is just walled off, C has a very handy excuse of saying that I didn't know possession had been given to me. And therefore, Rather than solving problems, the law sometimes seems to create further and greater problems. I thought this was an interesting aspect of the Transfer Property Act which we could all think about, and perhaps legislators in future would make some kind of solution to this. In India, there's another difficulty which, not a difficulty, but the courts have held. Now, sale agreements in India under Section 1A of the Indian Registration Act, and dare I say in Sikkim also now, a sale agreement cannot be unregistered and unstamped. And therefore, for a buyer to take this defense under 53A, he has to have a registered sale agreement and it has to be stamped. There is a very salutary provision in the West Bengal's Stamp Act, which is quite good. You can pay the stamp duty at the sale agreement stage itself, the full stamp duty, and have the sale agreement. If you make that the first document in your transaction, then when the sale deed is registered, you just pay 1 rupee on that, because you've already paid the stamp duty on the sale agreement. So these provisions have been provided, but as we all know that in India, registration and the payment of full amounts has been further complicated by the fact that the Income Tax Act also now says that you have to buy the property at the circle rate. And this applies to all persons who come under the tax bracket. So, if the property in the circle rate is worth 5 crores, you are only allowed a 10% leeway this way or that way. Otherwise, you have to show the transaction at 5 crores and you have to also pay stamp duty on the full value, the circle rate. And in your transactions, you have to show that you had the 5 crores to pay to the seller. So that has been tightened up considerably, and the penalty for that is quite severe. If you say, I bought it for 3 crores, then either you have to have a good explanation, like you paid the 3 crores 20 years ago or something, or that deficit amount of 2 crores will be added back to your income and you have to pay income tax on that. So very severe provisions have been provided in the Income Tax Act. I don't know how we're doing for time. In my enthusiasm, I had also read all the chapters of the Transfer Property Act, but I think we'll come straight to leases now. Topic of leases. I think in the state of Sikkim also leases are quite prevalent. I had the opportunity to, as usual with all my cases with Mr. Malik, it ended in a settlement. So unfortunately we were unable to have that determination on this very interesting point, which I'll come to in a minute. Just some fundamental what it is. A transfer of a right to enjoy such property made for a certain time, expressed or implied, or in perpetuity, in consideration of a price paid or promised, or of money, a share of crops, service, or any other thing of value to be rendered periodically or on specified occasions to the transferor by the transferee accepts the transfer on such terms. In simple language, this lease is a branch of transfer which is quite unique because possession passes, title remains, and possession passes for the possession and enjoyment passes for a specified period of time or in perpetuity. And for a long time as a young lawyer, and I always never thought of leases as transfer of property. there's a certain funny thing about a lease, and then when we look at the law, it says that it's a transfer of property. It's almost like hiring a taxi, for example. You don't have rights over the taxi. So, the ingredients of a lease are very, very specific and very, very sharply defined. It says a lease is not a transfer of ownership, but only of a partial interest in immovable property. An interest does pass, and that interest is the right to enjoy the property. And as in the case of mortgages, for example, some mortgages, a lease also creates the separation of a right of possession and of ownership. As we saw also in section 53A, we saw that ownership resides in one, possession resides in another. These are complex arrangements, and I would conjecture, because as I said, I don't have data for this, but the complex relationship with the mercantile community of England in its transactions overseas during colonial India must have given rise to, with venture capital coming, people investing in London, people who have no idea what Sumatra and Java and India or the sugar plantations of the Caribbean were, but they were reaping huge amounts of money in return because of imperial enterprise. It is after all the birthplace of the joint stock company also, where, as we say in Nepali, paisa lagaunu, mero pani paisa haldeau, kehi paya bhane ma pani bhagedar hunchu bhanera. That's how it starts, with wealthy feudal English capital then being put into these enterprises all over the world. So leases, of course, is probably one of the offsprings of that kind of mercantile activity that happened, where people said, give me possession of the place, I don't want the ownership. If I can use it, I'm a happy man, I'll have made my money. So that practice must have given rise to the formal idea of a lease. 107 also allows, very strangely, a lease in perpetuity. 106 is about duration, which we can all read, but it's not really very important. But leases how made also provides for a lease by perpetuity, or for, it says, from year to year or for any term exceeding a year, or reserving a yearly lend may be made by a registered instrument. And it requires, as we know, it requires a registered instrument. Although many leases are granted by way of unregistered instrument, the law says that it must be made by a registered instrument. And unfortunately, I think a lot of people don't know that. Or in practice, people make lease agreements and they leave it unregistered, which creates tremendous problems in future. But the essential ingredients of a lease gave rise to certain rights due to the enactment of rent control legislation in states. All over India, there was felt a need that the tenants should be protected and that the ordinary man should not be subject to the vagaries and whims of the landlord, who can evict him at short notice, terminate his lease. And so special legislation, which then came to protect tenants all over, dare I say also in certain parts of Sikkim, then gave rise to protections which were outside the purview of the Transfer Property Act. Now this became especially pernicious This became pernicious in metropolitan cities also, where, and as we have all heard of the thing, the leave and license agreements which are there in Bombay by which people occupy flats. And the practice that grows around that is you're not a lessee, you're not a tenant, you're not protected by the state enactments, you're just under a leave and license. Therefore, at any time you can be thrown out. Now, how did this come about? It came about because I think at some point some clever lawyer came upon Section 52 of the Easements Act. And this is now we're going in a completely different direction because Easements 52, what has it got to do with transfer of property? Easements Act, Section 52, says where license, where one person grants to another or to do a definite number or to a definite number of other persons a right to do or continue to do in or upon the immovable property of the grantor, something that would in the absence of such a right be unlawful, and such right does not amount to an easement or an interest in the property, the right is called a license. And Section 60 says, license when revocable, a license may be revoked by the grantor unless it is coupled with the transfer of the property, and such a transfer is in force, and the licensee acting upon the license has executed a work of permanent character and incurred expenses in the execution. So subject to certain conditions, a license can be cancelled at any time. So, invoking Section 52 and 60 of the Easements Act, landlords then began to grant licenses to their tenants so that they had the ease of eviction under Easements Act. And in Sikkim also, a person had lost a case on the ground that she had actually she was a licensee and it could be revoked and she could be evicted at any point of time. This was a nice way of circumventing the rent control legislation which protected tenants, saying, oh, no, you're not a tenant, you're a licensee. Then I came upon similar agreements in the metropolises where, again, real estate isn't in the hands of well-entrenched brokers and mafia. In fact, they even enforce the eviction for you if you want. And they were all doing this leave and license, leave and license, leave and license. Until obviously it was challenged. Person said, my relationship with the owner of the house is that of a lessee. And I am protected. But the document says I'm a licensee. Therefore, the landlord is trying to evict me on that ground. The courts then said, it doesn't matter what the form of the document is. What matters is the content and the relationship of the parties. And so, and this is obviously nowhere in the Transfer of Property Act. It's something that came out because of the TP Act as well as rent control legislation married together, which created, and as landlords would always say, it's so difficult to evict a tenant because of the almost extravagant protections that tenants have had so far. I don't know why that was enacted. I think perhaps the explanation could be, and I'm just sharing a thought with you here, that in the early days of this nation, in building this nation, the founders of this nation were acutely aware of the fact that the poor man, the disempowered, the man with no housing should be protected until such time as the state is able to make social housing. And its origins obviously lie in socialist thinking. But unfortunately, as we all know, the state really did not provide housing for the poor in any successful sort of way. So, in a sense, rent control legislation actually requisitions private housing by protecting it. It becomes almost like state housing. You can't throw out your tenant. That led to its own imbalances What kind of imbalances? The landlords began to charge salami because they said, oh, once you become a tenant, you're almost like a virtual owner of this property. So therefore, you just pay me the price at the beginning. So practices of paying premium, salami, which are completely outlawed. For example, in the West Bengal Premises Tenancy Act, the payment of any premium is completely banned and barred. But this practice grew out. After which, we came to such strange and almost ridiculous situations, where one day I settled a matter for some very poor people who were living next to my house. And the landlord said, we want to build this is an old shack, and we want to build a proper house, and we will give it back to you. At the bottom floor, you can take back the house. It was a good proposal. I negotiated it, settled it, and they agreed that they would vacate and it would be built and they would be getting it back. Then the landlord said, I'm investing so much money, so the rent will go up. So that's where it got stuck. And I asked my clients, the poor people, I said, can you increase the rent? So they said, no, we are so poor. They were really poor. I mean, I could see that. I asked them and I said, can you do it? They said, no, we can't. And then I asked them, what are you paying? And they said, we're paying 20 rupees per month. So it was intractable, because if I increase it tenfold, it becomes 200 rupees a month. In a nice concrete house that has been rebuilt, it's meaningless for the landlord. And I could see that this is because of rent control. They couldn't evict them. And if you go for a fair rent, you'll get a 10% increase. They'll get 22 rupees after fighting in the rent controller's office. So, therefore, ultimately that was settled. It's an anecdote. I think you would enjoy it, and you probably know the person who was there. It was Mr. B. Sharma, senior advocate, and his brother. And so we got stuck on that at that point, because I didn't know what to tell the tenants to pay. They nearly fainted when I said 300 rupees. And finally, and this is, I would pay tribute to Mr. Sharma and his family. I finally told Mr. Sharma, this building used to be a dharamsala once, and that was in my family a long time ago, so I knew it was a dharamsala. I said, from that floor above, you consider that your site, and below that floor, you consider it a dharamsala. These people are incapable. And I was amazed, because they stopped for a minute and they said, done. And till this day, that family, the second generation, is still living there because of his generosity and munificence. But I'm digressing from my thing. So landlords began, because of this difficulty to evict tenants, they began to disguise these leases as licenses, and invoking Easements Act, they began to draft these agreements as licenses. The differences were then detected by the courts all the way up to the Supreme Court. And the differences, if I may just briefly say, a lease is the transfer of a right to enjoy the premises, and a license is a privilege to do something on the premises which would otherwise be unlawful. A license is a difficult idea to grasp, so I'll give an example later on. A lease is a transfer of interest in the property, which is why it's in the TP Act, and which is why it requires a stamped and registered document. A license is a permission to occupy the property and no transfer of interest. A lease, if during the continuance of the lease any accretion is made, such accretion is comprised in the lease. And in a license, the license, it has no interest in the land, and therefore the licensee acquires no right by accretion. A lease is transferable and heritable. In the case of a license, it's non-transferable and non-heritable. A lease can be terminated by forfeiture, and in a license there can be no termination by forfeiture. It can be a lease can be terminated in the three ways given under the section 111 of the TP Act, and a license, this is most important, is revocable at the pleasure of the grantor. As I told a lease is not defeated by a subsequent transfer of the property, so it can be assigned. A subsequent transfer of the property terminates the license immediately. The death of either party does not affect the lease, and the license is usually terminated by the death of either party. And right to protection in a lease, right to protect possession of the property exists, but in a license there is no right to defend the possession of the property, which is why in Bombay we have the mafia going in and throwing things out of people's apartments, because they are on the ground that they are only licensees. So this was the subject of a determination in New Bus Stand Shop Owners Association, Corporation of Kozhikode versus Corporation of Kozhikode, 2009-10 SCC 455. After referring to those two sections, that is 105 of the TP Act and section 52 of the Easements Act, after referring to those two sections and after referring to the decision in Errington, the learned judge pointed out the distinction between the lease and the license by expressly approving the tests laid down by Lord Denning, and which may better be quoted. The quote from Lord Denning is, "The following propositions may therefore be taken as well established. To ascertain whether a document creates a license or lease, the substance of the document must be preferred to the form. The real test, that means it doesn't matter what it's called, whether it's a lease or a license. The real test is the intention of the parties, whether they intended to create a lease or a license. If the document creates an interest in the property, it's a lease, but if it only permits another to make use of the property, of which the legal possession continues with the owner, it is a license. And if under the document a party gets exclusive possession of the property, prima facie he is considered to be a tenant, but circumstances may be established which negative the intention to create a lease." So obviously the facts and circumstances will come into play in this. And in this particular case, it was found that the corporation retained exclusive possession of the shops because those shops were given for limited user. There were rules and regulations and conditions attached to the user of those shops, which clearly indicated that it was a license and not a lease. A good example of a license would be for if I were to own a garage and I would allow people to park their cars for the night. Now, in some ways, some elements of a lease come in because it's immovable property, the user is there, the enjoyment has passed. There is a specified payment, monthly payment, perhaps for a specified period of time. But possession, because there are many other cars which are also parked in the garage, possession of the premises has not transferred to any one of those users. In such a case, even though they are regularly paying their monthly dues and regularly using the garage, parking their cars, it is for a specified user, parking only. And so all these elements would bring it within the framework of a license and not a lease. So if tomorrow I said, now I don't want your car to be parked, the owner of that car could not sue me and say that I'm a tenant of his as a lessee. He would be considered to be a licensee. Similarly, in CM Veena versus Ramchandra Rao 2004 3 SCC 595, the learned judges held that the difference between a lease and license is to be determined by finding the real intentions of the parties from a total reading of the document, if any, between the parties, and also considering the surrounding circumstances. The learned judges made it clear that the use of the term lease, license, lessor, licensor, rent, license fee by themselves are not decisive, because clever landlords always say every month they will pay a license fee. They will not never say rent, because that will protect the tenant. The conduct and intention of the parties before and after the creation of the relationship is relevant to find out the intention. The learned judges quoted from the treaties, English treaties, in coming to their conclusion. Then we come to section 111, which is deals with termination of a lease. This is of great interest, obviously, to lessors.
Before you forget the license part, there is something very interesting, sir, most lawyers. Something called irrevocable license. I'll just give you an example. So in some cases, Your Honor, most of the judges in bar and in most of the cases, sir, the old timers in Sikkim, they would have given their landed property to school को लाए, government में फलाना को लाए, धर्मशाला को लाए, no, of course they would be gone. No, their few years of their the lineal descendants, no, they would suddenly come to the court and say that, "Hey, you know, it was in my great-grandfather's name. They were dictating the state government's name, veterinary बनाए, उनकी बनाए." And our case, there was one very interesting. There is one festival in North Sikkim called Namkrik Dam Festival. One joker came with a suit saying that the ground is near over. There the festival. I knew he was a joker. He lost also the case. Probably appealed and I don't know. But he never got that. And as fate would have it, sir, to finally lock it probably. That facial
Bluff.
Now, sir, in this case, interestingly, one of few of my judgments, though I tried to develop that jurisprudence, sir, but people could not appreciate it. I said that, okay, it's just a case, no, but still irrevocable license still would something circle fiction like so. But my problem with the parties would not have created irrevocable license. For a judge to incorporate an alien concept, I knew my limitations, but I thought maybe the higher courts, at least Supreme Court, will develop on it. This is how the clever judicial officer would normally do that also. They say, "Aldi rakho, groundsman, let it develop further."
It can be proper.
It did not develop. So, in those cases, sir, where the great-grandfather has given those landed properties, whereas for veterinary is being, government hospital is there since the last, let's say, 40-45 years, and the children have never raised a finger in them. Others have developed labor. It's not so what any sort of give us some food for thought.
And there is no payment of any kind.
There is one document saying that Arka Bahadur so and so, या Jagat Bahadur so and so,
दान दिएको छ।
दान दिएको, so समाजलाई दान दिएको। You would have a small place. Very interesting. Most of those with village background here, sir, including myself, we would have that idea. People Gentockians, Patnamchi, or Manganaites, or they would not know. But villagers like us, we know, sir.
You're absolutely right, because in my course of work in Sikkim, I've seen that, properties have exchanged hands on tremendously informal basis. Sometimes I've just seen 2 lines written by the local Mahajan, because both sides were illiterate. And it's written in Hindi. And on the basis of that little slip of paper, generations have been enjoying those properties. In the case that's cited, my thoughts are going in a different direction of a grant lost in time immemorial. There have been cases like that where people have been having water rights, or there's been a common space which has been given by the then landowner at that point of time, but the documentation is lost. We did one in Darjeeling where it's still going on, so we haven't got a decision. But a community was drawing water from a specific piece of land which belonged to another. And their thing was that their grandfathers had actually granted the water rights and that the community was drawing it. We had no documents. Everything was lost in, so in the law of easements, and we found also we didn't actually find exact relief, because in the law of easements requires for a person to be the owner of the dominant heritage and the subservient heritage. And this was a community that was saying, an entire village, almost like fishing rights, a village of fishermen saying we have fishing rights here. There we found some judgments which talked about ancient grants, and that if sufficient evidence was there, it could be deemed to be an ancient grant of some kind, and therefore, perhaps by prescription or by efflux of time, those grants solidified into a right. But these are all uncodified law. These are old judgments that we found. But this is.
Somebody has to file a case. Can he or she develop these rights?
We did exactly that with the water that was being drawn, because actually there was no.
So did you have lyrical license also? No.
About a license, I am wondering whether Section 60 doesn't stand in the way, because it says it may be revoked by the grantor.
That's what irrevocable license.
So, unless there are 2 conditions, coupled with a transfer of the property and such transfer is in force, and the licensee acting upon the license has executed a work of permanent character. If these 2 ingredients are there, possession and work of a permanent character.
And adding stopple also to that.
And estoppel, of course, standing by. So, termination of a lease, of course by efflux of time we know, limited in the lease. If it's granted for 1 year, it terminates on the end of the thing. Where such time is limited conditionally on the happening of some event by the happening of some event. Say for example, the lessee is given the lease of the premises until he builds his own house. Then when he builds his own house, the lease determines. Where the interest of the lessor in the property terminates, or his power to dispose of the same extends only to the happening of any event by the happening of such event. In the case of the interest of the lessee and the lessor in the whole of the property, the whole of the property becomes vested at the same time in one person in the same right. So the lessor becomes the lessee and the lessee becomes the lessor. By express surrender, that is to say the lessee yields up his interest under the lease to the lessor by mutual agreement. By implied surrender, by forfeiture, that is to say, he breaks an express condition which provides that on breach thereof the lessor may re-enter. Of course, the right of re-entry is now, I think, perhaps no longer available in India, where the Supreme Court has held that the landlord cannot re-enter and forcibly evict a person. He has to obtain a decree of a court. Or in the case of the lessee, in case the lessee renounces his character as such by setting up a title in a third person or by claiming title in himself. Or the lessee is adjudicated as an insolvent and the lease provides that the lessor may re-enter on the happening of such event And in any case of these cases, the lessor or his transferee gives notice in writing to the lessee of his intention to determine the lease. And then finally, on the expiration of a notice to determine the lease or to quit, or of intention to quit the property, lease newly given by one party to the other. So, clause H, of course, is usually displaced by rent control legislation again, where it provides for a specific period of time that you give 1 month's notice. And many objections have come that I have not received a notice under 111H, but that has been well settled by the courts of law, that the notice required for an eviction, especially under rent control, will not be the notice under section 111. With these words, we'll now come to gifts. Although the law of mortgages is also quite fascinating, and now in this age of trade and commerce, and debt society, as we have with Sarfezi and other enactments, I would have liked to focus on that also, but perhaps we can save that for another day. Gifts are defined. The transfer of certain existing movable or immovable property made voluntarily and without consideration by one person called the donor to another called the donee and accepted by or on behalf of the donee as a gift. Acceptance must be made during the lifetime of the donor and while he is still capable of giving. If the donee dies before acceptance, the gift is void. Transfer, how effected? For the purposes of making a gift of immovable property, the transfer must be effected by a registered instrument, signed by or on behalf of the donor and attested by at least 2 witnesses. For the purposes of making a gift of movable property, the transfer may be effected by a registered instrument signed as aforesaid or by delivery. So in the case of a movable property, the matter is very simple. You just give the property and the gift is complete. Such delivery may be made by, in the same way as goods sold may be delivered. Elements of a gift require, first of all, it's a gratuitous transfer of ownership made voluntarily without consideration by the donor to the donee. And the acceptance has to be made during the lifetime of the donor while he is still capable of giving, otherwise the gift is void. Of course, the acceptance does not have to be in the form of a signature or
So the consideration for
love and affection. That is the best consideration, and that particular phrase, love and affection, seems to have created a bit of a problem in certain cases which I'll come to, which relates to senior citizens. We've already read the requirements of registered deed and attestation. Section 124 says, a gift comprising both existing and future property is void as to the latter. So you cannot make a gift of a property which will be acquired or which will come into existence in the future. 125, a gift of a thing to 2 or more donees, one of whom does not accept it, is void as to the interest which he would have taken had he accepted. Very interesting again. It's given to your son and daughter. The daughter says, I don't want it. Then so far as she is concerned, that gift is void. But so far as the son is concerned, the gift is not void.
So in some cases, what I noticed, I give something to the six to them. There is a gifting to the for from the registration. So I after I have given him, I have placed him in possession thereof, I develop cold feet or I change my mind. Now he has already taken possession. Now can I say that no, that if the, although the get registered, should be cancelled or something? I don't think so.
The donee wouldn't be able to claim under that deed in the first place because it's not registered. So,
But he has been put into possession, sir. Now I am trying to revoke the gift. Then I revoke it, sir.
it is not complete, the gift, so revocation is not required.
I think so there's something, some mistake. The laws would, say something. Once I have given a gift, not any gift, put it into possession. Only thing is for registration, I will revoke the gift. I think that will not be possible. So I just want to, not.
This has come up in the case of parents who've given their children gifts, and sometimes on the understanding of maintenance, that my child will look after me. But the courts have been very stringent on that. They have said that you cannot, if your child doesn't look after you, if there's an express condition, therefore revocation, then in that case, I've made a small note on that. So if the gift, of course, contains a clause of revocation, then the matter ends there. But even so, revocation is conditional under section 126, which says, the donor and donee may agree on the happening of any specified event which does not depend on the will of the donor. A gift shall be suspended or revoked, but a gift which the parties agree shall be revocable wholly or in part at the mere will of the donor. Mere will of the donor is void wholly or in part, as the case may be. So, will of the donee, yes. Specified event, depending on the will of the donee, it can be revoked. But on the will of the donor, it cannot be revoked. A gift may also be revoked in any of the cases, save for want or failure of consideration, in which, if it were a contract, it might be rescinded. Save as aforesaid, a gift cannot be revoked. It's quite powerful, this phrase, a gift cannot be revoked. Nothing contained in this section shall be deemed to affect the rights of transferees for consideration without notice. So the illustrations would be also useful for us. A gives a field to B, reserving to himself with B's assent the right to take back the field in case B and his descendants die before A. B dies without descendants in A's lifetime. A may take back the field. This is the will of, it is not A who kills B or something, B dies. The happening of an event outside the will of the donor. Then A gives a lakh of rupees to B, reserving to himself with B's assent the right to take back at pleasure. At pleasure means the donor says whenever I like. 10,000 out of the lakh. So far as the 90,000 is concerned, the gift holds good. But as far as that 10,000 is concerned, it is void, which continues to belong to A. Because you cannot make a gift where you say, I'll take it back at pleasure. Interesting aspect of gifts, again, under 127 is quite a strange situation, where a gift is in the form of a single transfer to the same person of several things. So a number of properties are given to one person, out of which one is, and the others are not burdened by an obligation. Let's say a loan has been taken on one of the buildings, but not on the rest of the buildings. The donee can take nothing by the gift unless he accepts it fully. So If you're given 5 buildings and one has a mortgage or a loan on it, you can't say, this one's not mine and the rest I accept. Either you take the whole parcel or you refuse it. Then onerous gift to disqualified persons need not detain us. So I'm coming to the, excuse me, I wonder if I could have some water. I'm coming to an interesting by-product of the idea of gifts.
Plus, in Sikkim, I think we have to, so we have to government to discuss on the right of local laws also.
Yes, that's, I've already touched upon one or two, and I'll come to that. But gifts by, this was something of interest to me, because now we have the Maintenance and Welfare of Parents and Senior Citizens Act of 2007, and Section 23 said that transfer of property to be void in certain circumstances, where any senior citizen who after the commencement of this act has transferred by way of gift or otherwise his property, subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor, and such transferee refuses or fails to provide such amenities and physical needs, the said transfer of property shall be deemed to have been made by fraud or coercion or undue influence, and shall, at the option of the transferor, be declared to be void by the tribunal. A special provision was carved out here. That means that a parent gives it to his child and says, there's a clause which says that during my lifetime you're going to look after me, you're going to maintain me. And the child, the donee, doesn't do that. Then in that case, the donor can, at his option, he can have it rescinded in the same manner as a contract, as having been made by fraud or coercion or undue influence. And we see that now pervading especially poor people. We see that happening quite often. Because elderly people do not get housing loans. So they transfer it to one of their offspring who is eligible for a loan because he has a lifespan, he has some kind of employment. They transfer it by way of gift, and then he shows it up as security for the loan and obtains the loan. Later he stops looking after his parent. And at such a situation, Section 23 comes into play, but there are many buts to this, unfortunately, as decided in Urmila Dikshit, 2025 to SCC 787. It says, therefore, it is apparent that the Act is a beneficial piece of legislation aimed at securing the rights of senior citizens in view of the challenges faced by them. It is in this backdrop that the Act must be interpreted and a construction advanced that the remedies of the Act must be adopted. In Sudesh versus Ramti Devi, this court refused to grant the benefit of Section 23 in the absence of an averment. There was no averment that the transfer in question was subject to a condition for the maintenance of the parents. It was observed that when a senior citizen parts with his or her property by executing a gift or a release or otherwise in favor of his or her near and dear ones, a condition of looking after the senior citizen is not necessarily attached to it. On the contrary, very often such transfers are made out of, as you pointed out, love and affection without any expectation in return. Therefore, where it is alleged that the conditions mentioned in subsection 1 of 23 are attached to a transfer, the existence of such conditions must be established before the tribunal. So, I gave it because on the condition that my child would look after me. That has to be established. How that can be established is quite a difficult thing because it's not contained in the deed itself. Then, and Radhakrishna versus Pagdala Bharati, 2025, SEC Online is 1447. The Supreme Court approved of a finding by the High Court of Andhra Pradesh, citing another decision. That citation was, so far as the right of the deceased to cancel the gift deed for failure to maintain or look after the donor is concerned, the evidence of PW1 does not show that at the time of execution of Exhibit B1, there was such an understanding between the donor and the first defendant. In the absence of such agreement, Section 126 of the Act cannot be relied upon where there is no right reserved or understanding entered into between the donor and donee. Therefore, the decision first referred to cannot be pressed into for the benefit of the respondent herein. In fact, the law of this aspect is very clear, and the courts have repeatedly held a settlement deed once executed cannot be cancelled. If the donee does not maintain the donor as agreed by him, the latter could take proper steps to recover maintenance. It is not open to a settler to revoke a settlement at his will and pleasure, and he has to get it set aside in a court of law by putting forward such pleas as bear on the invalidity of the gift deed. While these riders, these are riders which have been put in, but when we think of the people who are invoking this law, senior citizens who are reaching the end of their lives, probably too ill, too poor to fight, to put such a onerous condition as to say that, well, you have to establish firmly and conclusively, either by a clause in the deed itself or by surrounding circumstances, is a difficult task. And I feel, this is my personal opinion, I feel that it defeats the very purpose for which this legislation was done. We are dealing with cases like this on an everyday basis where parents make the gift. Sagar is dealing with one matter where the mother gifted it to her son to get a bank loan. The son built a 4-storied building and is not allowing anyone to get inside. And the deed does not contain a clause saying that, I gave it to him on the ground that he would maintain or look after us. These are aspects that the law has to perhaps address in future. Then coming to the laws on Sikkim, I've just touched upon some general observations of the High Courts here. One is Tashitawa versus Keshri Pradhan, in which the court has held, it is clear as day that any transfer of property under Section 123 of the TP Act mandatorily prescribes that 2 witnesses should at least attest the registered instrument executed for the purpose of making a gift deed of removable property which has been signed by or on behalf of the donor. The Lordship was discussing registration of document rules, 1930. And there was an argument put forward that the TP Act actually displaces those rules. And it was held that the registration rules, 1930, functions independently of the provisions of the TP Act in terms of the explanation here and above. The question of the registration rules, 1930, being superseded by the TP Act does not arise. It's a piece of logical thinking, I feel, because the Transfer of Property Act merely makes a requirement of registration. Now, in Sikkim we are faced with a unique situation. All over India, we use the Indian Registration Act. And this is very exhaustive. It prescribes procedures, registers, the manner in which it is done, special firebox for wills, everything is there, appeals in case of non-registration, everything is contained in this, but as far as Sikkim is concerned, it's not applicable here. So, the argument that the TP Act displaces was really not logical because it does not concern with registration. It doesn't operate in the same field as the rules operate, and the rules as an old law still hold good. So, in Dashida came to the specific finding that the rules are not superseded. Another observation in Dashida, which is also very interesting, is the court examined Exhibit 4 and found that it finds foul of the mandate of Rule 10 of the registration rules. Because Rule 10 says that all corrections, interlineations, etc. must be attested by the parties to the document with their signature on it. Procedure to be observed in the Registry of Deeds, where a power is given to do a certain, all interlineations, erasures, alterations appearing in the document must be attested by the parties to it with their signatures before such document could be accepted for registration. And the Lordships found, as held by this court in KP Bandari, should the rule not be followed, it lends suspicion to the circumstances of correction. As far as back as 1936, in Nazir Ahmed versus King Emperor, it was held that where a power is given to do a certain thing in a certain way, the thing must be done in that way and not at all. So, the Lordships found that Exhibit 4 contained interlineations, erasures, etc. A lot of corrections without any attestation by the parties. And they held that it was not in terms of the requirement of the law, and as such being the position, it is not a valid document. This I am bringing up in the context of what I said about the law of registration in Sikkim, which needs, to my mind, needs a rapid updating to meet contemporary requirements, because transactions become complicated. There are reservations made, there are conditional transactions, there are contingent transactions, and that space requires proper conveyancing, which would also be good training for the lawyers in draftsmanship. But as it stands, the procedures that I've seen, first of all, quite lengthy, because there is a preliminary inquiry. Interestingly, the registrar under the Indian Registration Act is only required to see the valuations and the amount of stamp and whether the deed is in order. But in Sikkim, under the rules, almost an investigative power has been given to the registrar, who sometimes, as we have seen in certain cases, sends the inquiry officer to the house of the donor to find out whether his wife has agreed to the gift or not. And then there are other intermediate reports about the site and the location of the property. It's very exhaustive the way the rules have been framed, and rightly so, perhaps in those times when in Sikkim we didn't have vast bureaucracies to deal with aspects of land possession, record of rights, etc. But now, if we look at the manner in which, for example, expensive pieces of property are being conveyed by deeds which are, again, liable to be thrown out, as in this case, just because one interlineation was not attested or there is something suspicious. And I've seen, especially in some of the major cases concerning agricultural land, the documents themselves leave much to be desired as far as accuracy is concerned. Yes, sometimes it's sale deed is struck out and written gift deed, and there's no attestation. Was it a sale? Was it a gift? It says gift deed there, and then it says 2 lakh rupees down there. So it's a sale down there, it's a gift up there. I'm bringing to light these things for food for thought for future reforms, as we call it. And second is, now when I come, it's a modern state. We pass pharmaceutical industries, we pass huge resorts, hotels, establishments. We see the best of cars here, and there is a need for transfer of property to be also meeting up with the need of the times. Coming next to the next thing that I saw as far as the law in Sikkim was concerned was there were these old notifications. I'm sure all of you are familiar with this. This was the notification of 1928 to all Qazis, Tikadars, managers of estates. In continuation of the previous rules, His Highness Maharaja of Sikkim is pleased to order that the law of registration applicable in the state shall be amended. And then it said any documents such as mortgages and sale deeds and other important documents and deeds will not be considered valid unless they are duly registered. The term important document has also been dealt with by the High Court of Sikkim. And then the 1946 notification, which amended the para 2 of notification, the 1928 notification. Any unregistered document which ought, in the opinion of the court, to have been registered may, however, be validated and admitted in court to prove title and other matters contained in the document on payment of a penalty of up to 50 times the usual registration fee. So, the High Court held that thus the notification of 1946 is relevant for the present purpose. On a perusal of the above laws, it transpires that Section 122 of the TP Act pertains to how a gift is to be executed. 123 explains how the gift of immovable property must be effected, while notification of 1946 lays down how an unregistered document can be validated. The purpose of the above section and notifications are specific, and the question of the notification of 1946 being promulgated by the Maharaja of Sikkim and therefore inapplicable to the instant situation is a misplaced argument of the learned senior counsel. True, the notification is one of 1946 and therefore protected under the provisions of Article 371 FK of the Constitution of India, which commences with a non-obstante clause. But this is not the contest at hand, which pivots around the contention as to whether Exhibit A ought to be validated. The notification of 1946 allows an unregistered document which the court is of the opinion ought to have been registered to be validated on the payment of penalty up to 50 times the usual registration fee, and the contents thereof to be admitted in court to prove title or other matters borne in the document. This being the situation, I am of the considered opinion that the document sought to be validated, being bereft only of registration, ought in substance to be compliant of the provisions of Section 122 and 123 of the TP Act, the said Act having been extended and enforced in the state of Sikkim on 1/9/1984, prior to Exhibit A, which was executed on 21/12/2001. This court is conscious that a document need not adhere to a specific format. In other words, substance and not the form of a document is relevant, but a glance at Exhibit A clearly indicates that it does not conform to the legal mandate. Therefore, the court cannot perpetuate any irregularity for that matter, sans compliance with the provisions of law. It goes without saying that the provisions of 122 and 123 of the TP Act go hand in hand with notification of 1946 and are not at cross purposes. Validation of a document after 1984 can be allowed in terms of notification if the requirements of Section 122 of the TP Act are fulfilled, but that of 123 of the TP Act remains incomplete on account of non-registration of the document. Although it was contended that this court in Kulbadur had held as follows. In Kulbadur it said that unregistered document is wide enough to include every unregistered document. Their lordships held, coming to the last paragraph 13, by ordering validation of Exhibit A, this court would be implying that the document is legally sufficient and binding, which is not the correct position, as the document falls short of the legal requirements. That apart, no court has opined that the document ought to be registered, which is a prerequisite under the notification of 1946. So registration has been held to be mandatory. Then, finally, again, these are very brief words on something that I haven't touched upon as yet. And this is the idea of lis pendens. Section 52. This is a very sometimes misconstrued provision because of the draftsmanship of the section itself. I'll just perhaps, but we can get together. And it's been correctly interpreted by the Sikkim High Court. I've met many lawyers and sometimes even judges who say, oh, there's a case pending, the matter is sub judice, and you cannot sell the property while the case is pending. And parties have been even sometimes injuncted from selling, because this wording of this section is, during the pendency in any court having authority within the limits of India, excluding the state of Jammu and Kashmir, or established beyond such limits by the central government, of any suit or proceeding which is not collusive, and in which any right to immovable property is directly and specifically in question, the property cannot be transferred or otherwise dealt with by any party to the suit or proceeding so as to affect the rights of any other party thereto, under any decree or order which may be made therein, except under the authority of the court and on such terms as it may impose. Explanation need not detain us, but the specific words cannot be, the property cannot be transferred. This, at first blush, seems to impose a bar on the transfer of the property during the pendency of a suit. But in Tashidawa again, it has been correctly interpreted as to mean so as to affect the rights of any other party. Is perhaps the operative part. So we take a situation where there is a suit concerning a property, and during the pendency of the suit, the property is sold on to XYZ. The effect of the doctrine of lis pendens, as the High Court says, is not to annul all the transfers effected by the parties to a suit. It does not annul those transfers, but it only renders them subservient to the rights of the parties under the decree or order which may be made in that suit. In other words, its effect is only to make the decree passed in the suit binding on the transferee, that is, the subsequent purchaser. Nevertheless, the transfer remains valid, subject, of course, to the result of the suit. In A. Nawab John, this court has explained, this is a citation of a quotation from another judge. This court has explained the law in this regard, and we may usefully reiterate the same with reference to the following. It is settled legal position that the effect of Section 52 is not to render transfers effected during the pendency of a suit by a party to the suit void, but only to render such transfers subservient to the rights of the parties to such suit as may be eventually determined in the suit. In other words, the transfer remains valid, subject of course to the result of the suit. The pendente-like purchaser would be entitled to or suffer the same legal rights and obligations of his vendor as may be eventually determined by the court. So if the man who sold the property, the party to the suit who sold the property loses the case, the transferee also loses the case. That's all that this pendants seems to suggest, and this has been consistently held by the courts. Otherwise, if suits took, as they usually do, take a decade and a half to be decided, the property is locked up. And in many cases, as we've seen, the transferee is also allowed to intervene in the suit and contest the suit of his own accord. So it's a salutary provision, and of course it imposes a rider upon the transfer, saying transfer karo, no problems. But outcome of the suit, if the decree is against you, you'll be bound by it. If the decree is in favor of your transferor, then you will also win the property. That's all it seems to say. And I found that this is a provision worth mentioning in the context of the Transfer of Property Act, because it is something that arises quite often in matters between parties concerning immovable property. But I've seen many positions, many views from people saying you cannot transfer during the pendency of a suit. It is a sub judice, and there's a kind of an unspoken injunction upon the property, which is not the correct position of the law. So I've come to the end of my small session. I hope you have got something out of it. I'm sure at my age I've forgotten, I had forgotten half of what I had read about the Transfer of Property Act, and it was quite a task for me to scramble back and recover some elements. And thank you for being such a patient and receptive audience, and especially Sir, who's been very interactive. I think there's some Q&A, is there?
All right, sir. Thank you, sir, for your insightful and enriching session. With your permission, sir, we shall open the floor for a short interactive session.
For the information that you shared with us. So, as someone from Sikkim, I always come back to the point of differences with the Transfer of Property Act in the central level. And here in reality, when we go to the department to transfer property, the problems that we face. So my question is very simple. Transfer of Property Act being sort of a parent act. So what acts or rules govern the transfer of property here in Sikkim? Do you have any idea about it? So you just mentioned about some rules also in your discourse. So exactly what rules apply when we have to transfer a property here in Sikkim? So if you know, it will be quite helpful. Thank you.
In force in Sikkim, 1st of September, I think, if I'm not mistaken. So, although the Transfer of Property Act is not considered to be a comprehensive code on all transfers, and it does not encompass all kinds of transfers, it certainly does govern and can apply to most transfers. Prior to 1984, some of the old orders that I've seen have actually referred to the Transfer of Property Act, and in many states where it was not enforced, the principles had been extended, because like the Eastlands Act, for example, has been extended in cases where it's not enforced, in states where it's not enforced. So there were transfer of property rules. I haven't come across any kind of enactment like that. In Sikkim, it was the registration of document rules itself, 1930, that was, And that, because it's a protected law, is not going to be tampered with for a very long time. So,
Sir, but there were 2005 rules. I don't know whether it has been implemented, but this Sikkim transfer land.
there is, yes, 2005. Yes, I did see it. I have it here somewhere.
So the former law secretary says it is not easy.
That will require a huge search on the net for notification. I did take a look at it, but it was seems to create at section 3(1), save as otherwise provided in any other law, rule or order and as provided hereunder, no transfer of land belonging to any person by way of sale, gift, exchange, mortgage or sublet with possession shall be valid in favor of a person who is not an agriculturist. This pertains to agricultural land. But after that, there are embargoes upon the registrar and penalties and appeal provisions. I took a look at it, but I confess I was a little non-committal about this. It's such a sweeping embargo that I think if this were to be enforced, it would bring all transactions to a standstill as far as agriculture is concerned. But there are such laws which have not been enforced. There's some enforcement